Welcome to Shan Thever Law Firm. Our law firm has a well-respected immigration team. Our team has helped people from all over the world to obtain business visas, investment visas, higher education visas, and family visas to come to the United States to live their dreams. Shan Thever founded this firm in 1982. For the last 33 years, he has led his team in representing some powerful and elite clients. He started his immigration practice when he was in the University of California at Los Angeles Law School.
Thank you, Kate, for starting this visa discussion.
Ladies and gentlemen, my name is Shan Thever. My law firm helps foreign investors come to the United States with their families to become permanent residents by investing $1 million or $500,000 in the U.S. economy. The investment should employ 10 U.S. workers for 2 years continuously. They can start a business, they can send their children to public schools, they can live in any states in the United States. Our firm has an extraordinary immigration team. Our team member, Tom Fisher, was a very high official of the United States Immigration Department. He was the regional director for the Immigration Department for Southern region of the United States. He served as an official for well over 20 years. He created policies for the department. He created procedures for the department. We have another member in our team, Mr. Solomon. He has served as a visa officer for the American Embassy abroad for well over 20 years. I myself am doing immigration work from the time I was a law student at University of California in Los Angeles. Let's discuss E-1, E-2 visas. There are countries all over the world with whom the United States has some form of treaty that helps investors come to the United States and obtain an E-1 or E-2 visa. What is E-1 visa? What is E-2 visa?
Sean, basically the E-1 and the E-2 visas, these are treaty investor visas and treaty trader visas. I think to put this in perspective, we need to look at our chart to see where we are. At the very top, for those individuals who are in the United States and eligible, there is U.S. citizenship. Supporting that U.S. citizenship, and before one becomes a U.S. citizenship, is what we call the immigrant visa, which is the green card. And you get this through family, employment, or even through what they call the diversity visa or the lottery, which, by the way, opens up October 2016 online for qualified individuals. Supporting the immigrant visa section is another one called a non-immigrant visa. And the non-immigrant visa is a visa that basically is similar to some of the properties up here, except for one difference. And that difference, Sean, is that the non-immigrant visa is temporary in nature. It will have a time frame that's allocated by law or by the admissions officer, granting how long that person can stay here. There are many, many non-immigrant visas, and the government classifies these A through V. So now let's talk about one called the E-1, which is the treaty trader, and E-2, which is the treaty investor. Most of our clients, Sean, as you know, come looking for the treaty investor visa. And the benefits of the treaty investor visa is that there is no time frame of when it expires. There are some countries that are not eligible, though, and this is where we have to take a look at what countries perhaps do have eligibility for the E-2, E-1 visa. For example, when I look at the list that the State Department puts out, and basically the E-2 and the E-1 is a treaty between that country and the United States government. So I look at like E-2s, and we're looking at Bangladesh, Bahrain, Taiwan, Pakistan, countries like that, that there are eligible individuals who can qualify as an investor. Now, for those of you who are familiar with the EB-5, which is the treaty, which is the investor visa, the minimum requirement here is $500,000 US, and it may go up to $1 million. U.S. Versus the E-2 treaty investor, there is no investment ceiling. It depends on the complexity of the investment. An example, if I am in Pakistan and I want to open up a restaurant or buy a restaurant, let's say in Los Angeles or New York or New Orleans, Louisiana, and if that restaurant has $300,000 to $400,000 to $500,000 potential income, if I invest $100,000 into that restaurant and own 50% or more, I qualify for an E-2 non-immigrant treaty investor visa. Now, initially, the government, because it's a brand new visa application, will only give me usually 1 year. And at the end of that 1 year, I have to then resubmit for an extension showing that I have done business, it's for profit, and I can show a workforce that's increased. If I can show that, then, and if I apply again overseas at the U.S. consulate or embassy, then I will get that visa for 5 years.
Then that means they need to leave the country to go to the embassy to get the visa renewed for another 5 years.
Or if they decide, I don't want to go back to the country, we can do the adjustment extension here. However, they can only get 2 years, regardless of whether they go back or stay here. If the business is an ongoing enterprise for profit, can show documentation of that, tax returns, sales, profit and loss statements, and the like. I know people, and we have people working with us that are here as E-2s for over 25 years.
Correct. Now, Bangladesh will be a treaty investor E-2. Pakistan can be treaty trader and treaty investor E-1 and E-2.
That's correct.
Sri Lanka, treaty investor. Taiwan, Denmark, Turkey, they are all E-1 and E-2.
That's correct.
Okay. If any member of the audience wish to know whether their country is in this category, please call us or send us an email at shan@thever.com. Now let's go to L1 visa. What is L1 visa?
An L1 visa is what we call an intra-company transferee. Again, when we look at our chart here, and we look at the different non-immigrant visa classifications, we see A through V. We've already discussed the E-1, Sean, and the E-2, the treaty trader and the treaty investor, and we know that only certain countries are eligible for this. Now, when we look at the L is a intra-company transferee, and the L is open to nationals of every country in the world. There are no restrictions. The great thing about an L is that it can lead to a permanent residency. If a person, for example, is in, let's use Bangladesh. I'm in Bangladesh and I have a business, and I want to open up a subsidiary here in the United States. I find a location, I get incorporated, I lease the property or buy the property, I then start my business. There is no financial minimum that one has to invest to start that business.
That is significant.
Yes. Now, obviously, the government will want to see a subordinate staff, and they'll want to see some other normal requirements for a business. But once that is established, and we have that capability to help them with the corporate work as well as the immigration work.
And we do.
And we do that on a day-to-day basis. The individual normally would get that visa for 1 year because it's a brand new business. At the end of 1 year, we will file for an extension for them. Now, the L1A is a visa that has a maximum of 7 years. So initially, we're going to get 1 year. At the end of 1 year, we're going to apply for an extension, and they're going to give us 2 years. Normally, our clients are very good businessmen or women, and at the end of that 1 year period, their business is really starting to pick up in the U.S. So when we get that extension into that second and third year, they then, if they meet all the requirements, are eligible to file for a green card without going through the labor perm process, which is great. So this is a very, very good visa. There is no numerical, like the E, there is no numerical ceiling on it. You know, the EB-5 has 10,000. The H-1B non-immigrant visa has 55,000. But the E, whatever the ceiling will bear. The L, the same way. So it's a great opportunity. It leads to permanent residency for the whole family. And while the the person is transferred, their spouse can work in the U.S. somewhere else. They do not have to work for that business.
But they have to have a business in the old country because it is called as an intra-company transfer visa, which means the original company has to apply on behalf of this individual to transplant an executive from that company into this country.
That is correct. They must maintain what we call the parent company overseas because we have to show what we call a qualifying relationship between the parent company in whatever country that may be to the subsidiary in the United States. And normally that's not difficult. And secondly, or lastly, there is no limitation on the type of business. This can be apparel business. This can be hotel motel business. This can be food service. This can be engineering. This can be retail merchandise. This can be auto parts. This can be anything and everything, as long as we have that business relationship between the parent company and the U.S. subsidiary.
Thank you, Tom.
As I said in the beginning, we are a very powerful, an extraordinary, experienced, and strong immigration team. Our immigration team will work for you. Please send us an email at shan@thever.com and tell us what your visa needs are. Please check our website, www.thever.com. Please call us at 310-489-7837. Thank you for visiting our website. We are your strategic partners for your visas.